Good afternoon, everybody. My name is Bianca Moreras. I'm your moderator and host, and we are here today it's time to get your you know what together. Okay, we'll discuss everything from estate planning to how to avoid probate administration and everything else in between. And of course, you have your phone, you're on mute. Thank you so much. But if you have any questions, you can ask us them directly, or you can put them in the chat and we'll be happy to speak them out loud without divulging who you are. So this is a safe place to be to ask any question that you want. So let me introduce to you Samantha Fitzgerald. Samantha is an attorney in plantation, and her firm is 100% focused in estate planning and probate and trust administration. She's been practicing for over 20 years. She's a CPA and has an LLM in tax. And my name is Bianca Moreras. I will be your host, and I am a business development and career transition consultant and coach. I bring over 37 years of experience to the legal market. My specialty is attorneys, and I love what I do. So thank you for all coming. Samantha, say hello.
Hi, everyone.
And we will get started. Thank you. Hi, Lauren. We're just getting ready. Welcome. So today we're going to talk a little bit about your kids, and yes, they need estate planning too. So I have some questions that have been posed by other clients from time to time, and I'm going to get started with the first one. Samantha, what do you mean kids need estate planning?
So both minor children and adult children, because we tend to think of our adult children still as children, but they do become adults at some point, even though they're our children. There's various different types of documents and planning that you need to put in place for your minor children as well as your older children. So you have to think about them. It's not just you and your documents for your stuff, but you have to think about the kids as well.
Okay, so let's start with, how do you name a guardian for, your minor children?
Okay, so that's one of the biggies. That's one of the triggers that oftentimes gets people to do their own individual estate planning is they know that, well, what if something happens to me? Who's going to take care of my children? So the place where you actually appoint a guardian for your minor children is in your will, your last will and testament. That's where the court will go looking for your appointment. Now, you probably could put it in, like, let's say you didn't have a will for whatever reason. If you put it into some sort of writing that was executed in the same way with witnesses and a notary, it's going to show your intent. And that's the purpose of it when you're gone, to show the court what the parents wanted for the child. So that will probably work as well, but the statute actually uses the term will. So that's, what you want to do, and that's where you would normally see it. So if you have a will, that's, where you would do it.
Okay. Well, can you also name co-guardians?
You can have co-guardians as long as they're a married couple, because practically speaking, the child is going to live with the guardian, and the guardian is going to be in charge of all of their legal decisions. So you couldn't have two different people living in different places because, they're not divorced parents. They can't share custody of the child. So as long as they are a married couple living together, they can serve as co-guardians. So one thing that we always bring up when we're doing documents for our clients, and they say, well, I want to, appoint, Bob and Sue. Bob is my brother. Then we have the, well, do you really want to appoint Sue, or do you just want to appoint Bob? So kids can still obviously live with the couple, but, do you want to actually give the in-law legal rights over the child? Sometimes the answer is yes. It depends on the circumstances. There's no black and white rule for everything. Sometimes yes, sometimes no. And when the answer is yes, oftentimes we'll add in some language that in the event the couple divorced, then the in-law is no longer eligible to serve as guardian.
Wow, that's starting to get complicated. Wow. So when would that guardianship be appointed?
So guardians get appointed typically when the parent dies, um, and the still a minor. You may have a temporary guardian appointed. So if somebody's incapacitated, there could be a temporary guardianship, or when they pass away, the guardian would be appointed at that time. So whatever you put in your documents now isn't isn't effective until something triggers that, whether there's an incapacity issue or a death.
Okay. Well, you brought up incapacity. What happens if you're still alive and you're incapacitated with that guardianship or your child?
Yeah, I mean, somebody needs to have immediate legal authority over the children. So they'll look to your documents as well to see, who the parent wanted to appoint. So it's not just death. People think, well, hopefully I won't die anytime soon. But you could be incapacitated. You could be in a car accident. You could be in any sort of accident. I mean, a month or so ago, a plane fell down out of the sky onto the highway here. So anything can happen any given day. So if you're sick, you have a heart attack and you're rushed to the hospital, maybe you're in the hospital for a month, who's going to take the kids? Now, sometimes it's more of a practical issue. If you have a very close family member that can swoop in and take the kids and everybody's fine with that, then that's going to happen. Nobody's going to interfere with that. But if you don't have that, or if people are fighting over the children, then you should have a legal document in place which clearly specifies who the parents want to serve as that guardian.
Oh, wow. Okay. Well, what if, you have a minor child and an adult child? Could that adult child be the guardian for the minor?
They could, yes. So sometimes we have clients that want this. Other times, other instances, you want to think about whether you want to put your young adult child in that role. Oftentimes they may be away at college, so now you're asking them to leave college, come home and take care of baby brother or sister, which may be what everybody wants, but it's something that we talk through at our meetings when we're doing documents for clients, and just something that they have to give some thought to. But they can, once your child is an adult, they're an adult, they can serve as guardian. Now,
That
the
kind of,
court may not, just because you put something in your documents doesn't mean it's a given. So the court still has to actually appoint that person as the guardian of the minor child. And they may look at this and say, son, ma'am, you're not capable of taking care of a 14-year-old child, financially, mentally, physically, whatever the case may be. So your documents don't control, they are just persuasive to the court.
wow, it sounds like a good movie or a movie I might have seen already. Wow. So, what is the age of majority?
In Florida, it's 18, but there's a couple of states where it's not. But that's the overwhelming majority is 18.
Okay. Yeah, and I think of my own children at 18 years old. I don't think that I would want them to take care of anybody. It's like being an adult child. Well, so go ahead.
Of course, but it's really, really young.
That's young. I think it's young too. So what happens when my child turns 18? Is there anything that I need to do?
Absolutely. So this is what I kind of hinted at the beginning. So when your child turns 18, they are no longer a child, they are an adult. You can't make decisions for them. You have no access to their medical information or their medical records. And as an adult, whatever assets they own themselves, it's just like you and me. If they don't have somebody appointed legally to be able to make financial decisions for them, manage their assets, Nobody can do that. Just because you're a mom or dad or you're paying the college tuition bill doesn't give you special privileges. So we always counsel our clients as their children are turning 18 that they should have the child themselves should execute a healthcare surrogate designation and a durable power of attorney, especially when they're going off to college. They've turned 18, they're off to college, and they have some sort of medical problem. Maybe they're in the hospital and they can't communicate. Mom or dad frantically calls the hospital, wherever they are, tries to find out how the child is, get information. Unless you get somebody that breaks the rules, they're not going to give you any information. Especially if the child is coherent and they're saying, don't disclose any information, because maybe they're doing something they shouldn't have been doing. And they specifically verbalize, don't disclose any information. Then they really can't. They definitely won't disclose any information at that point. But if you had a healthcare surrogate with a HIPAA release, which is the medical privacy law, then you have every right to it. So it's important for any child over 18, but super duper important if your kids are going away to college, absolutely get that healthcare surrogate and durable power of attorney in place.
Wow, they should make that part of the list when they tell you what you need to pack, right? It's just
in college yet, so I don't know what it looks like, but absolutely that should be on the list, 100%.
Yeah, absolutely. That's great. So you mentioned 2 different documents that are important. Is there any other documents they might need?
For the most part, that's what they need. They need to appoint somebody to make medical decisions for them, and they need to appoint somebody that has authority over financial decisions. They need alternates, so maybe they're appointing mom and or dad, but they should have some alternates, if they have a trusted sibling, or an aunt or uncle or something like that. Alternates are always good. The other thing I always tell clients related to their adult children is make sure they designate beneficiaries on their financial accounts. Oftentimes they don't have a lot of money, but sometimes they do. Sometimes they've saved away money, and they don't think about death or beneficiaries. So a lot of times, God forbid something happens to them, but we see it, unfortunately. We see tragic things that happen, and they have a bank account. Sometimes it's a very small bank account, and there's no beneficiary on it. So guess what? Now it has to go through probate. So now you're spending a lot of time, a lot of money to collect maybe a really small asset, which is a real shame on top of a tragedy. So telling them to put beneficiaries on checking accounts and savings accounts and any life insurance they might have, or if they have a job and they've opened up some sort of retirement account, all their financial accounts should have beneficiaries designated on them, in addition to the healthcare surrogate and the durable power of attorney. And then another one is, it's very common for parents to buy their kids cars and give them a car when they're 16, so they're a minor, they can't own the car themselves. But when they turn 18, if that's their car, turn it over to them, transfer the title, get the liability off your plate. Why share the liability with them? They are not the best of drivers, so why are you going to subject all of your assets to your child's accident? If it's their car, turn it over.
Good idea. I guess I need to get busy myself. Okay. So if there's someone that I want to appoint for guardian, but they live out of the country, what do I do? Is that possible?
Yeah, so it's a kind of a weird situation, because when somebody's appointed guardian by the court, it's a Florida court procedure. So Florida does not have jurisdiction over anybody out of the country. So the will nominate this person to be the guardian, and practically speaking, what will happen is the child will most likely be, however it happens, transported over, to that. Usually it's a family member, without any court involvement here in the States or in Florida. So practically speaking, that can be challenging, logistically. So what happens if you die in a car accident today and your family lives in India? Happen to have a lot of Indian clients, and a lot of their relatives are in India. It's pretty far away. How's the kid going to get there, and who's going to take care of them in the meantime? So sometimes we will appoint temporary guardians. or temporary healthcare surrogates. I don't think we mentioned that before. That's another thing that you want to do for your minor children is not only appoint guardians for them should you be incapacitated or you die, but appoint somebody that can make medical decisions for them in your absence, which may be you're away on vacation, you're out of town, or you're incapacitated. So somebody can make a medical decision for your child in your absence. So sometimes we'll appoint these temporary guardians, somebody that can immediately take the child here in Florida and then arrange for them, to get over to the family member in the other country. That way it's just clear in the document who's got the authority, because sometimes this is a friend, a trusted friend, a neighbor, if they have no other family members here. So, if DCF swoops in and they're like, okay, we got to, take physical custody of this child, and the neighbor's like, oh, I'll take them, they wanted me to have them. Yeah. Who says? So having a document which clearly nominates somebody to have the authority is really, really crucial.
Yeah, this is such good information. Thank you, Samantha. What is the benefit of us or my leaving my estate in trust for my kids?
So many benefits. So the biggie is avoiding a court-administered guardianship. So a guardianship is comprised of two pieces. A guardian of somebody's person, that's the person that physically takes care of the ward or the child, the person that makes legal decisions for them, and that sort of thing. And then there's the guardian of the property. So whether it's an adult or a child, the guardian of the property is the person that manages the financials. Oftentimes, it's the same person that's the guardian of the person and the property. So if you have a minor child and you leave them assets, you die and things pass to your minor children, it has to go into a court supervised guardianship so that the guardian of the property is now there. If there's no assets that pass directly to the children, the court will appoint a guardian to take care of them, a guardian of their person, but there's no assets to manage. So it's really simple. You appoint the person and there's really nothing to account to the court for because there's no assets, there's no annual accounting, or anything like that that gets filed annually with the court. You get appointed and that's it. You're there until they're 18. But when you leave them assets, now the court's involved all the time. And the money goes into a restricted bank account. You can't get any money out without getting a court order. So you have to go to court and you have to explain to the court why you need money. And the court says yes or no. Sometimes that's a good thing. So you can't have somebody stealing assets or wasting them. The court takes it very seriously and really, really scrutinizes distributions to children. But when you have somebody doing the right thing and really taking care of the kids, it's really hard. It's very expensive. You have to have lawyers. There's lots of filings that get done. If you don't have a lot of money in the guardianship, you can really drain a lot of it in lawyer fees and expenses and court fees. And, it's a real shame. Then when the child turns 18, the guardianship terminates because they're now an adult and they get whatever money is there. If it's $1 million, they're getting $1 million. There's no stopping it. They're entitled to it. That's way too young to get all their money. Even if it's a small amount of money, it's even worse because they're going to blow it all and then it's gone forever. So putting a trust in place not only avoids the guardianship, but it allows you to then dictate when the child is going to get that money, at what ages or certain events, if they graduate from college. You get to pick who's in charge of the money as opposed to the court deciding who the guardian is. And it won't all go to them when they're 18, On top of that, so not only avoid guardianship, avoid all that expense and hassle, you can, if the child wants to go to summer camp, just write a check. The money's right there. You don't have to get a court order. You don't have to wait. But it also provides significant creditor protection for the child. As long as the money's in that trust, it will be protected from creditors. It will be protected if the child had to file a bankruptcy. It will be protected if the child, depending on the terms of the trust, of course, but, a good trust will protect the money if the child is doing drugs or, alcohol, or if they're getting sued, if they were incapacitated, if they join a cult, we have language like that in our trust. All sorts of issues. It has significant protections in there. And then it also provides for what happens, God forbid, the child dies. Where does the money go? So if the money goes directly to them, they own it outside of a trust, guardianship's terminated, and then they die, well, who knows where it goes? It depends. But if you leave it in a trust for them, then it will go wherever you say it goes.
Wow, that sounds like the best policy. It really does. I hope everybody has one. And if you don't, you know where to go to Samantha. So I do have one last question, and then I'm going to open it up to those on the call. This question is from a young lady. She says, my child is disabled. Is there anything special I need to do?
Absolutely. You want to have special needs trust language in your trust, or supplemental needs trust language, same thing. It's crucial that you have that, because if they are receiving any sort of need-based benefits, such as Medicaid or SSI, which oftentimes a disabled child or person are receiving, they will lose their benefits when you die, even if it's in a trust. You need to have special language in your trust so that they're not automatically disqualified from these benefits. So you can have your cake and eat it too, sort of. You leave their share into a special or supplemental needs trust, and that trust has restrictions. It can only pay for certain things, and then they still qualify for their benefits. So it's a great alternative. We include them in all of our trusts just in case, as a backup, a contingency, in case any child or an adult that's disabled.
Well, I didn't know that. So I'm going to be spreading the word to friends that I know have disabled children. That I didn't know they lose their benefits if you pass. That's kind of scary when you think they're going to be taken care of if you don't know the law. So that was such good information. I have to get busy myself here. So are there any questions, Lauren or Ikanye or Charles from the audience on this topic, or anything that's burning in your mind, maybe facing the trusts, or any explanations on any of those documents that weren't clear? You can speak up or you can put it in the chat. Ikanye, I see you took off your mic.
I put my question in the chat, but I'll ask it.
You did? I don't see it.
I just sent it.
How often do you have to update this stuff?
Stuff. It really depends. There's no rule per se. So part of it depends on your circumstances and what's going on in your life and what may have changed. We like to reach out to our clients every 2 years to just touch base and see if anything has changed. So it really depends. There's no rule of thumb necessarily, but you want to think about it. Every couple of years, you at least want to think about what's going on in my life. Have I gotten married, gotten divorced? Has anybody died? Have I had more children? Are my children older now? That's a big trigger for our clients. They'll do their documents when their kids are maybe, 15 and 17, and now they're, mid to late 20s, they're working, they're responsible, and it's time to change, some of the terms of the trust. What we see a lot of is people that you've named in these documents as your fiduciaries. So maybe in your healthcare document or your verbal power of attorney, people pass away, unfortunately. So sometimes, we need to update them for that. We try to put in a lot of alternates in our documents so that our clients don't have to update them all the time. We'll get calls a lot of times, somebody telling us something happened. We look at their documents and say, well, you're okay. You don't need to make any changes now. We try to anticipate as much as we possibly can to make the document last as long as possible. But you shouldn't do these documents and set them and forget them for 20 years. You should think about them a little bit. Sometimes it's up to the client to reach out to their attorney to tell them what's going on, because we don't know what's happening in the client's life.
Did that help you, Ikanye?
Yeah, so I can have one now and simply just put that whatever I have for this son of mine, it's not gonna go to the future wife or the future grandchildren. My
Absolutely.
future grandchildren, I can put that now.
Yes.
Absolutely.
Okay.
Yeah.
Our clients is that they don't want their assets going to their child's spouse.
But we are so happy that you came today. We want to thank you. We want to remind you that this program, same time, same place, every month, we have different topics. If you have a topic of interest, please let us know as well. You're welcome to call the office anytime and speak to Andrea. I'm so sorry, Andrea. And she'd be happy to either get you to Samantha or answer your question. And we will see you again next time. We hope this benefits you. And we will see you on May 21st. It's already the 21st. Wow. It seems like this year is also flying by. So we're happy you were here. Thank you so much. Samantha, any last words?
Thank you everybody for coming. I really appreciate everything and excited to have you. Hope to see you next month and the months after that. And have a wonderful weekend.
Yep. Everyone have a wonderful weekend. Thank you so much
Thank
for
you.
coming. And
Bye.
remember, it's time to get your you-know-what together.
Yeah.
Talk to you next month.
Bye.
Thank you. Bye-bye.